Hey all, welcome to the next session of Arbitration Boot Camp. And as you know from the topic, we've got arbitration agreements, the good, the bad, and the ugly up for discussion today. And I thought that I would cover the entire topic today, but I realized how big a topic it is. So I've now decided that this is going to be part one of the topic, and the next session on April 13th will be part two. And I think once we get into it, you'll realize what a vast topic this is. So this is the sixth of my series, and thanks for those of you who've given me feedback and requests for topics to cover. Again, if you want to reach me, please contact me directly. When your emails go to marketing, it usually takes me a couple of days to actually receive them. As usual, I will be spending about 45 minutes talking about this topic. I'll leave about 15 minutes for comments and questions. And I've got the Q&A box open, so if you've got some questions as we go along, I'll do my best to answer them during the course of my, my talk. But if I can't get to it, I'll deal with it at the end. A little bit about me. I'm a partner at Lerners and an arbitrator at Arbitration Place. And this series is intended to provide practical advice and information in an area in which there's lots of academic information out there, but not a lot about actually utilizing some of those concepts in your practice. And that's what I try to do in this series. After this session, you'll get a recording of the series, and you'll also get a list of the resources that I mentioned. So again, today's topic is the arbitration agreement, the good, the bad, and like the ugly. And those of you who have been around the block for a while knows that there are a lot of ugly arbitration clauses. And part of this is because the people who draft the clauses are not the ones invariably who are required to either challenge or defend them. And the good news is that increasingly I'm hearing from counsel, usually at large firms, that their solicitors or corporate colleagues are asking their advice on drafting arbitration clause in larger commercial agreements. And the reason that's good advice is for the first time, counsel and parties are actually turning their minds to what they would like to happen if there is a dispute that arises, instead of looking at a clause for the very first time once a dispute arises and trying to figure out what it means and how it can either be avoided or enforced. So this session really isn't about drafting an arbitration clause. It's more about what to do when you are stuck with an arbitration clause, and in some circumstances, U.S. counsel will be asking to enforce it, or you may be asking to try to avoid it. And if you're an arbitrator, you'll be asked to interpret it. But before I get there, I'm making a plug, just as I did in my last session, about something I'm offering from now until the end of April. And it's kind of a professional responsibility thing that I'm doing this year. And so it's essentially a public service. And I'm offering my services as arbitrator for a flat fee, using an expedited procedure for matters valued at less than $500,000. Or if what you'd prefer is some case management within your litigation and you'd like the final determination of the merits to be done by a court, I can do some of the interlocutory motions. So that's my plug. If you're interested, give me a call. If you know someone who else is interested, pass that information along. But I'd like to get back to our topic for today, which is, again, the basics of arbitration agreements, pathological arbitration agreements, which I'll cover. And then what I think is the most interesting and one of the most difficult topics is multi-tier arbitration agreements. And some of the other topics that I've represented in the advertising that I would deal with today, I'm going to push off to the next session. So, and before I forget, in May, I'm going to be what I'm calling a magic 8-ball session, which means ask me anything, send me some questions. So between now and May, if you've got something you don't know and you'd like me to answer, or if you're too shy to ask somebody, you can send me a note, and I won't identify questioners, but I can deal with them all in the May 8th, the May session. So the first principle, before we talk about arbitration agreements and whether they're good or bad, we have to remember that an arbitration agreement is just a contract. And that often gets forgotten when all of the other arbitration concepts are discussed, jurisdiction, for example. And so it's really important to go back to fundamentals when you're either enforcing or defending an arbitration agreement. Like any contract where the parties disagree on what it means, that the objective of the interpretation exercise, either by the arbitrator or by the court, is to determine the parties' intentions. And so the general principles of contract interpretation apply. And as we know from the SATVA case, contract interpretation involves a question of mixed fact and law. So who interprets the contract? We know that under the principle of competence, it is the arbitrator that makes that decision and determines jurisdiction usually, because that's usually what the issue in the arbitration contract relates to. We know first that it's the arbitrator, and then there are two exceptions where a court may determine the issue. So that's the Dell against Union des Consommateurs decision of the Supreme Court of Canada in 2007. And that court said that a court may determine jurisdiction and interpret the arbitration clause if it's a matter of a question of law, or if it's a question of fact and law where the issues of fact can be determined on the face of the record. So that's one exception. The second exception arose in the Uber case, and there the court called the arbitration clause an anti-arbitration clause and determined that the court can determine the issue where there is not a likelihood that the parties will actually get to arbitration. Because as you'll remember in the Uber case, that was certainly the situation when there was a cost associated with sending a case to arbitration that the claimant couldn't afford. So again, if we look back at arbitration agreements as contracts, you know that the clarity of language is absolutely essential. And because parties often don't turn their minds to the issue of the arbitration clause, sometimes there are disastrous, or as I call them in this session, ugly arbitration clauses. And so if you're turning your mind to it, you must ensure that the arbitration clause is both practical and usable. The party's intention to arbitrate must be clearly stated, because what will invariably happen once there is a dispute is one party will no longer have the same interests in trying to work with the other party as it did when the parties were entering into their business agreement. So there will be an incentive on the part of one party to try to resile from that intention, and the arbitration clause, if it's not clearly drafted, will present an opportunity for that. And in my experience, parties are often surprised about what the arbitration agreement means when they turn to look at it when there's a dispute. And of course, ambiguity leads to disputes, increases parties' costs, and causes further delay. So some of the common problems in arbitration clauses are whether arbitration is mandatory or permissive, whether there's a step that must be taken before arbitration is permitted, and that's what we call multi-tier agreements, and what I'm going to focus on today. And whether there's no seat specified, whether there's no law specified, whether confidentiality is a term of the arbitration. It cannot be assumed, and there are occasions when one party requires or wishes confidentiality more than the other, and that can provide leverage for the party that isn't as concerned about confidentiality issues. Whether the arbitration is final and binding, and that language has been held to not be determinative of whether an appeal is permitted. So that if there's no appeal permitted, that must be absolutely explicit in the arbitration clause. And whether the process makes sense. If the parties in their arbitration clause have provided, for example, a three-party tribunal in circumstances where the proceedings are actually worth a relatively small amount of money, that process may not make sense. And other terms that become problematic and are very common are those which require the arbitrator to issue a decision very shortly after the arbitrator has been appointed. So those are some of the common problems which will come up if you've got an ambiguous arbitration clause, and will, as I said before, give grounds for somebody trying to avoid an arbitration clause and make it more difficult for somebody hoping to enforce that clause. Pathological clauses. as they're so called. These are essentially clauses in which the arbitrator simply or the court cannot interpret them. They are fundamentally flawed. And then there is a risk that the parties had an intention to arbitrate, but the arbitrator simply or the court cannot interpret that clause. And so while arbitrators will interpret the clause to give effect to the party's intention to operate, so much as the language in the clause allows, the arbitrator will not create an arbitration clause. The arbitrator is limited to simply interpreting it. So when you're looking at the arbitration clause or drafting it, you've got to be very careful that what you've got is something that may well be vague, but if it's pathological, it's going to create real problems for the party who wishes to arbitrate. Some examples of pathological clauses are the arbitration agreement names a specific arbitrator who either refuses or is unable to accept the appointment as arbitrator. In some cases, that arbitrator may be deceased or may not have that time available in his or her schedule. The arbitration agreement names an appointing authority that no longer exists. This sometimes arises when there is a historical contract, one that goes back decades. I've seen those in some of the cases, and the appointment authority no longer exists. What do you do about that? And another one that is difficult is the arbitration agreement sets requirements for the arbitrator, which quite simply cannot be fulfilled. And I had an experience with that in which the arbitration agreement required that the arbitrator be one of the top accounting firms who also is trained in arbitration. And I was unable to find a single person who fulfilled those two requirements. And in the abstract, they sound like they should be fairly easy to fulfill, but they're not. And so that creates a problem with whether the arbitration can proceed at all. These are, of course, extreme examples, but they're a very good indication of why it is so essential that the arbitration agreement be clear. And again, there are tools that can be used that are basic contract tools to either interpret the contract or the arbitration agreement or to challenge it. So contra proferentum, for example, subsequent conduct as a tool to interpret an ambiguous contract. So the reality is that if both parties are still committed to arbitration, most of these problems can still be fixed, even as they relate to pathological clauses. But the difficulty is, will the good faith efforts of the parties to arbitrate still raise issues that they simply can't overcome? And so here are some suggestions about ways parties can fix a pathological or ambiguous arbitration clause to still achieve arbitration, but to not get down into the details, which are likely to create problems. And that arises invariably when a party says, well, there's a reflexive response to another party's suggested term once a dispute has arisen. So there are ways to smooth those waters. So for example, can the parties simply choose a new appointing authority? That means they're not agreeing on a specific arbitrator necessarily, but if they can't agree, can they get a third party to appoint that arbitrator? Is there a standard clause from some of the rules that both parties support? So the ADRIC rules, the VANIAC rules, the ICC rules. Even if parties aren't going to agree on a process, will they agree to apply a well-established neutral set of rules that'll actually help them pave the way forward to a meaningful, effective, efficient arbitration? Is this an issue that can be raised at mediation? If the parties are prepared to at least discuss a mediation on the merits and they can't get there, are they prepared with a facilitator to get down the road toward a process for an arbitration? So, of course, the consequences of an ugly arbitration clause are jurisdiction issues, delays, litigation, probably, which most parties who want arbitration want to avoid. So I'm now going to move on to what I think is one of the most important issues to think about with respect to arbitration clause, and one that there is a lot of confusion about and is not well understood, and that is what are multi-tier arbitration clauses and what are the effects of a multi-tier arbitration clause, particularly if you don't get it right. So a multi-tier arbitration clause is typically a clause that requires either negotiation or mediation before the parties are permitted to go to the next tier or the next stage, which can be litigation, but I'm going to focus on arbitration. And of course, if the language isn't clear in the multi-tier arbitration clause, it can create problems because it's not clear when one tier ends and the next tier begins. And what ends up happening is one party would like to then move to the next step, and the resisting party says, well, we haven't actually fulfilled the requirements of the previous step or the previous tier. So for example, there is a requirement that the parties mediate or negotiate beforehand. What happens if one party absolutely refuses to engage or has engaged, but the other party views those negotiations as not being in good faith? And you'll see a lot of these clauses which require the parties to negotiate in good faith. Or what if a clause requires that the business leaders of the two parties talk before you go to the next step? Sometimes it's mediation, sometimes it's directly to arbitration. And some clauses even provide that for example, two CEOs must negotiate. Well, what happens if the parties have one CEO and one president negotiate? Is that fulfillment of the tier or not? And what happens if one party simply refuses to engage, and so the other party's attempts to negotiate or mediate are futile? Will the court or the arbitrator require that the party fulfill that requirement, even though it's absolutely incapable of occurring because one of the parties is not interested in participating? So the legal issues that I think are most important when dealing with multi-tier arbitration clauses are, first, is the next step in the tier optional or required? And that brings into play the concepts of jurisdiction versus admissibility, which I think are quite misunderstood by many of our colleagues. And the second issue, which is even more thorny, is when does a limitation period start to run? If there's a pre-arbitration negotiation phase, and that is something that can easily trip up counsel. So I'm going to start with the jurisdiction versus admissibility point. Again, this is a question of contract interpretation. Does the arbitration agreement require that negotiation or mediation occur before any party has the right to proceed to arbitration? And that is a matter of contract interpretation, and there are signals in the language that suggest one or the other. So if there is a requirement that mediation or negotiation occur first, and it's characterized as a condition precedent, or must or shall language appears, then that's a pretty good indication that unless the mediation or negotiation stage has been fulfilled, there is no entitlement for either party to go to arbitration, and those cases invariably end up in the courts. If it's a matter of admissibility, that's essentially a procedural issue. And so you will see sometimes in these multi-tier arbitration clauses that there's no absolute requirement or condition precedent that the parties negotiate before either party is entitled to start an arbitration. But there is a general intention that the parties would like to engage in some kind of a negotiation without prejudice to the parties' rights to move to arbitration if, for example, the negotiation proves to be futile. And sometimes there are options, a variety of options set out in the multi-tier clause, all of which are optional. And if they're not successful, or if one of the parties views them as unlikely to be successful, the parties are entitled to go to arbitration. Now, it's in the context of admissibility that you often hear the language that the arbitration is not ripe. And what that really means is that the arbitrator has jurisdiction So this is a matter in which the arbitrator has determined that the preconditions to arbitration have been fulfilled. But there's a reason why the arbitrator thinks that the parties aren't yet ready to arbitrate. That's the ripe issue. And that can arise. I've seen a lot of those in kind of construction type contracts, where in order to start an arbitration, a party must issue a notice of arbitration, or there must be a process where a party sets out the issues that are in dispute, and there must be an opportunity for the other side to respond within a particular number of days. And so the arbitrator may send the parties back and say, until the process that the parties have provided for in their arbitration agreement has been completed, the matter is not yet ripe for arbitration. So parties fulfill those requirements and then come back to me. And I think that's where there tends to be a fair amount of confusion among counsel about whether those are issues of admissibility or jurisdiction. And the significance of getting those right, of course, is that if the arbitrator makes the wrong decision because the arbitration agreement is not clear, there could be a jurisdictional error. And of course, that leads to a whole bunch of problems. It leads to the possibility of a set aside later on or a challenge to the arbitrator's jurisdiction. And what it means is the parties are essentially in limbo while the jurisdiction issue gets determined. The arbitrator can deal with the jurisdiction issue in one of two ways. The first way is to have it determined as a preliminary issue. And that it means that the arbitrator may decide the issue of jurisdiction before making a decision on the merits. And of course, if the arbitrator decides that he or she doesn't have jurisdiction, then that's the end of the arbitration. And so there is provision in the Ontario Arbitration Act, the Model Law, the BC Arbitration Act, and all of the other provincial arbitration acts that are based upon the more modern acts that provide that a party may challenge the jurisdiction of the arbitrator. The arbitrator may deal with it as a preliminary objection. And if one of the parties is not satisfied with the arbitrator's decision or ruling, then the matter may go to the court, which may decide the matter is the language. And there is not a clear understanding in the case law about what decide the matter means and what is the form of review that the court will take if it is called upon to decide the matter of the jurisdictional ruling that the tribunal has made. And one of the most important cases that deals with that issue, if you face it, is Russian Federation against Lex Toma 2021 4604 Divisional Court. And this was an application under the model law, but the principles should apply equally in the domestic context because the language is the same. And what the court decided is that the review that the court makes of the tribunal's preliminary jurisdiction order it's a de novo hearing, which means additional evidence can be admitted, and that was the actual issue in Russian Federation and Lex Toma. But the arbitrator must make a correct decision on his or her jurisdiction, and that's entirely consistent with the Mexico and Cargill case, a decision of the Ontario Court of Appeal, 2011, Ontario Court of Appeal 622. It decided in the set-aside context that where there is a jurisdiction issue decided by the arbitrator must make the correct decision. And so an early jurisdiction issue can then go up to the court, as I've just described. There's no further appeal from that order. But the alternative for the arbitrator is to decide the jurisdiction issue at the end of the arbitration when the merits issues are decided. And that's very common because often an arbitrator will say, well, I have to decide the jurisdiction issue only, with knowing all of the facts of the case. I can't decide it independently. And so I simply am going to require that the parties go through the costs and the time of the entire arbitration in order to determine whether I have jurisdiction. And so you can see that when you go back to the arbitration clause, the difference between jurisdiction and admissibility is absolutely critical. I've got a question here. What factors do you think should guide the consideration when an arbitration should be stayed where a party fails to undergo a pre-arbitration step couched as mandatory because the party thinks that compliance will be futile. Well, you've actually anticipated something I'm going to be talking about towards the end of this presentation. But at the end of the day, despite the fact that the parties, the case law says generally that arbitration clauses are contracts and the court should interpret them as contracts, there is an interesting development in the law in which courts are very reluctant to overturn a jurisdiction issue of a tribunal and to find that the parties intended to arbitrate. So there's a bit of a relaxation of the principles when it relates to arbitration agreements. And I'm going to refer to you, and I don't have it in front of me right now, but I'm going to refer you to this fabulous article by Professor Joshua Carton in the Canadian Journal of Commercial Arbitration, in which he talks about multi-tier arbitration clauses. And most importantly, he gives a whole bunch of cases that tell you how courts have made determinations where these clauses are difficult, ambiguous, perhaps pathological. So I hope I answered that question for you. Next, we get into the issue of admissibility. And again, that is considered a procedural issue, which is something that can't be appealed on an interlocutory basis and must be dealt with at the close of the arbitration as an appeal or a set-aside. Usually it will be a set-aside on the basis that there's been an unfair treatment by the arbitrator of one of the parties. So determining the difference between jurisdiction and admissibility is absolutely incredible, or absolutely critical. Then the next, I think, extremely important issue, and one that you may know less about, because I knew very little about it until I started monitoring the cases, is what happens when you have an arbitration agreement and there's a limitation period looming. And this is very scary stuff. If the lower tiers are not complied with expeditiously, there is a chance that the limitation period will expire before the process, the negotiation, mediation, and then arbitration process gets underway. And so if the parties are if one of the claimant, for example, has not yet decided whether to start a claim and there's a multi-tier arbitration clause, it may be that by the time all of the steps are fulfilled, it's too late. The arbitration agreement the limitation period has already expired. So if you have a multi-tier arbitration clause, apart from giving clarity in the clause about when the limitation period starts and when it starts, then the best thing to do is to bring your claim early. I have seen parties start litigation in order to preserve the limitation period. But the difficulty with that is if the proper forum is arbitration, the litigation is then at risk of a motion to stay the proceeding. So this issue can create really difficult problems. So when the cause of action ultimately arises and when the limitation period starts to run is determined by the limitation period legislation in the seat. And the question really is the date when the dispute arose and the date when preconditions have been completed or ought to have been completed. And so if you've got a vague multi-tier arbitration agreement, which doesn't give clear deadlines when the negotiation phase has ended and arguably the cause of action arises, you can end up with a lack of clarity on when the limitation period has started. So, for example, in many of the provinces, the cause of action arises when the claim has been discovered or when a reasonable person knew or ought to have known of the cause of action. And where the limitation period starts to run when a claim was discovered, usually that occurs in the limitation legislation when the claimant first knew that a proceeding would be the appropriate means to remedy the claim. And so when does that occur in the middle of negotiations? So In a case called PQ Licensing, SA, LPQ Central Ontario, and I'm going to give you these case citations in the resources later, 2018 Ontario Court of Appeal 331, the court found that the limitation period started to run when the mediation had concluded. That seems relatively straightforward. A recent decision of the Ontario Court of Appeal called Maisonneuve against Clark, 2022 Ontario Court of Appeal 113, was much more difficult. There was a process in which the parties were negotiating, and it wasn't clear when the negotiations stopped and one party had stopped negotiating. And so this becomes obviously a question of fact. And in this case, the two parties set out the history of the negotiations, and the court made a determination of when the other side ought to have known that the negotiations were at an end. And in this case, the claimant argued that the negotiations became futile. And so the question for the court was, well, when did they become futile? And you can imagine how difficult that can be where the parties are posturing in a negotiation. And so here in this case, the counsel said that negotiations were over, but there were still a variety of issues on the table. And so the question was, when ought the party that wanted to pursue the arbitration have known that arbitration was the appropriate means to seek a remedy? In Alberta and Nova Scotia, for example, the limitation legislation provides that the limitation period commences no later than the date the claimant first knew that the injury warrants bringing a proceeding. And there's a case called HOOP, H-O-O-P-P, Realty Inc. versus Emery Jameson, 28 Alberta Queen's Bench, 276, and 2020 Alberta Court of Appeal 15. And this contained a mandatory arbitration clause, and the knowledge of the lawyer was attributed to the client as to when the limitation period started to run. And there was an issue about where the appropriate forum was, and it turned out that the lawyer chose the wrong forum and learned about the mistake. And by that time, the limitation period had expired. And so this case is all about the claim against the lawyer for proceeding in the wrong forum and the knowledge of the lawyer being attributed to the client. So the really important message here, I think, is to be mindful of that issue when you're drafting or dealing with a multi-tier arbitration agreement, and to act cautiously to ensure you don't miss an arbitration agreement, which can miss a limitation period. But of course, that's very, very difficult. I've never seen the limitation issue dealt with in the arbitration clause itself. And I've actually never seen a model clause from an institution dealing with this issue. So one of the best ways to guard against that in the arbitration clause is to ensure that there is very clear language about when each step ends, each tier ends, and the next stage begins. And a party may formally declare the dispute resolution failure. So if you act for a claimant and it is not entirely clear when the limitation period has started to run, one of the helpful things may be to simply write to the other side and make that declaration. Then if you're going to have an issue about limitation period, you'll at least know it early on. So the real problem here is that many parties drafting arbitration clauses simply do not turn their minds to the limitation period issue. And many of these clauses haven't been tested. So there's a real risk out there for counsel, for sure. So I'm now going to turn to the PowerPoint presentation, which you've seen on the screen as I've been talking, and give you some examples of arbitration clauses. So the first one, here's my contact information, by the way, if you do wish to call me directly. But here's what I'm calling the ugly multi-tier arbitration clause. So first it says all disputes between the parties that cannot be resolved. Okay, so that's a fairly broad clause. So far, seems okay. That cannot be resolved by good faith negotiations. Already there's a problem, because what constitutes good faith negotiations? That it's difficult to have an objective measure of whether a party has been acting in good faith or not. And when tempers rise and the dispute becomes heated, it's quite common that one party will believe that the other party is not acting in good faith. So you've already created an impediment to knowing whether an arbitration can proceed, because it's not clear that the good faith negotiation stage has been completed. Then we see should be referred to a panel. Does this mean must be? That's not clear. May not be a mandatory clause, because the language should is not entirely clear. Then it should be referred to a panel of 1 or 3 arbitrators. 1 or 3, you've already created a barrier to understanding who your adjudicator is, with the power to resolve all disputes under the laws of Ontario, and who will report their decision within 30 days of the referral. So you've also created another problem here that I talked about, that the arbitrator is required to render an award within 30 days. I'm assuming referral means appointment. And that may be a very, very short period of time when the parties haven't decided on process yet, or there hasn't been a first procedural meeting at which process has been discussed, and it's not clear what the evidence will be, how complicated the issue is likely to be, how many witnesses, or whether the matter will proceed by witness statement, or whether there will be document production disputes. So this multi-tiered arbitration clause is ugly for a whole bunch of reasons. So I'm now going to go to what should be in a good multi-tiered arbitration clause. Clarity of language, make it practical. Look at the clause from the perspective of one party being intransigent and resisting negotiation, mediation, or arbitration, or all of the above. If one party is intransigent and is not interested in participating, is the clause workable? Can you understand how to get to arbitration when you can't meet the earlier 2 requirements? Or are you satisfied that if those requirements aren't met, you want the choice to go to litigation instead of arbitration? So this all boils down to what the party's intent, and what you should make sure of is that what the party's intent is reflected in the language. Each step should be clearly mandatory or permissive. May or shall, condition precedent, those kinds of words can be used to show whether the parties want mandatory arbitration and want to make the issue one of jurisdiction. There needs to be clear timelines and objective standards to determine compliance at one step and whether the next step may be invoked. So there may be, for example, language which says that if after 30 days, the parties have not or are unable to mediate and resolve the case, any party may issue a notice of arbitration and the matter must be arbitrated, something like that. That means that if one party is not prepared to participate in the process, it doesn't prevent the other party from moving on to arbitration. When does the limitation period start to run? When does a cause of action arise? Again, if there are clear timelines, it is much easier to have a definitive answer to when the mediation stage has ended and the dispute stage has begun. And then simplicity. The simpler your clause is, the fewer steps that there are, the easier it is to avoid procedural problems. So next we'll go to, I know this is a lot of text on the screen, and I know that this violates one of the, it's probably the first rule of PowerPoint presentations, but I'm doing it for a reason. So I've got the ADR Chambers multi-step dispute resolution clause, and I'm not going to read it. But what I'm trying to emphasize is that these clauses are usually longer than simply an arbitration clause. And if they're going to have clarity in the steps, you simply need more language, and you need to set out those steps clearly. And so these kinds of clauses are excellent models which can be modified. So for example, the ADR chambers clause and some of the other ones I'm going to take you to provide specifically for mediation at ADR chambers, and then arbitration with an ADR chambers arbitrator under the rules of ADR chambers. So you'll see this in the next few clauses I'm going to use. So the institutions provide you with these clauses, and they also provide you with a way, if you'd like it, to ensure that your mediator gets appointed if the parties can't agree, and that the arbitrator gets appointed if the parties can't agree, and that the rules are set out if the parties can't agree. Now, of course, if you would like to use the rules, but you wouldn't like to use an ADR chambers arbitrator or mediator, you can, of course, modify that. But these kinds of clauses provide very good models for the kinds of language and the kinds of steps that you should consider in drafting your clause. And I would recommend that you start with one of these model clauses and modify it as you see fit, because at least you'll have the building blocks and you'll be able to address the issues and decide whether you would like them in your clause or not. So you'll see, for example, the language in the first paragraph, which says that the parties must agree to mediation before pursuing any other proceedings. And so this draft allows people to pursue either arbitration or litigation, and specifically says that it doesn't preclude a party from seeking injunctive relief. Then a party may serve on the others a notice to resolve a particular dispute by mediation. So one party can invoke that right by serving a notice. And if the dispute has not resolved within 30 days of the notice to mediate, any party may terminate the mediation and proceed to arbitration. So again, clear deadlines and the ability to move to the next step, even if one party can't participate or refuses to participate. Similarly, here's the Vaniac clause. Now here it says each of the parties shall make bona fide efforts to resolve any disputes. Again, I think that language is problematic, but the Vaniac language has been used, and I know that it has been used successfully. This sets out kind of some of the philosophical issues: amicable negotiation, efficient process. The parties agree to attempt to resolve all disputes, again, before a neutral person appointed by Vaniac and administered under its commercial mediation rules. And then arbitration, again, if the dispute cannot be settled within 30 days after the mediator has been appointed or such other period agreed to by the parties, the dispute shall be referred to and finally resolved by arbitration administered by Vaniac pursuant to its rules. And then the last one is the ICC clause, which is much shorter. And in the event of a dispute arising out of or in connection with the present contract, the parties shall first refer the dispute to proceedings under the ICC mediation rules. And the commencement of proceedings shall not prevent any party from commencing arbitration. So this is a clause which doesn't require the mediation before arbitration and leaves the option open. Oh, and I've got the ICDR one as well. The parties agree to first try and settle the dispute. So this is kind of language that you can use to try to structure a mediation, multi-tier arbitration clause that will ensure that you're not stuck at the first stage without the ability to go further, unless, of course, that's what the parties want. They want to leave their options open. So again, some issues that can come up. What does negotiation mean? How do you determine good faith? Is it a requirement that there be negotiations before arbitration? Is arbitration mandatory or permissive? If it's mandatory, what is the specific precondition that must be fulfilled before arbitration can be commenced? Are reasonable attempts to comply sufficient? And most importantly, there should be clear timeframes for each step so that it is absolutely clear both when the limitation period starts and when a party can move on to the next step. Now, you may be asking, why is it necessary to have a multi-tier arbitration clause when parties can decide at any moment that they would like to try to resolve their case by mediation? And I think that's actually a great question to ask in any case, because of the potential complication of a multi-tier arbitration clause. So one of the answers is, I'm not going to use one. But some parties like it because where there is a long-term arrangement, they really want to try to preserve that relationship before anyone moves to arbitration, and they want that recorded in writing. So that's a dictate that the parties make when they've got a relationship based on trust. And because it may have an impact on a limitation period, parties may say, I don't want to go down that road, and I'm not going to put in a term that requires mediation or negotiation beforehand, and just hope that when I'm ready to settle, the other party is ready to settle as well. One of the issues that counsel will know is that sometimes one party doesn't want to raise the issue of mediation or negotiation because that's viewed sometimes as a indication of weakness. And so those issues need to be balanced when you're thinking about a multi-tier arbitration clause, or you're thinking that it sounds like it's too much trouble than it's worth. So that's all I have to say about multi-tier arbitration agreements and basic principles of arbitration agreements. I don't see anything in the Q&A box, so I'll give people a few seconds to put something in if you haven't yet had a chance to do so when you do have a question. But I want to remind you of my preview of the session that's going to be held in May. I'm calling it the Magic 8-Ball session. And so if you do have any questions about any topics I've covered, any topics I haven't covered, and which you'd like to hear about at that session, it'll be a mixed bag of all sorts of topics, and I will gear it essentially to the things that you want to hear about. So send me a quick email, let me know your questions, and our next session will be on April 13th. It'll be part 2 of arbitration agreements. And then again, we'll get into the Magic 8-Ball. So I don't see any questions in the chat box. Have a great day. We'll see you next time.